This is Talk Business and Politics with Roby Brock.
Welcome to the program. Joining me now, John Brummett, columnist with the Arkansas Democrat-Gazette. Good to see you a little bit ahead of the July 4th holiday. You got big plans for the holiday?
Just to observe and eat well, basically. That's my plan. What about you?
Well, I am going to take a few days off, and which I rarely do, but I will do that to just have some downtime and be casual. Maybe I'll buy some sparklers or something, and
Well, I recommend that to be patriotic, to be demonstrative in your love for your country. I think you should do that. I think you should. All right.
Let's begin with a Friday afternoon state court ruling out of Pulaski County Circuit Court. Judge Herb Wright makes it official that the LEARNS Act cannot start until August 1st because the state legislature did not follow the Constitution for emergency clauses. This is going to be appealed immediately. It's thrown everything in flux. It doesn't seem to unravel the LEARNS Act, but it seems to delay the LEARNS Act. What's your interpretation of what the ramifications for that decision are?
I got to tell you, I just finished the first draft of a column. I'm trying to get ahead on holiday week columns. And I said, the LEARNS Act is not yet in trouble or that much of a mess, but it is in quite a flux. And you just used the same word. So I think that's what it is. I think if we agree on that spontaneously, then that's the state of, it's in a state of flux. It's uncertain as to what happens. Does the Supreme Court, which I think is on vacation, of course they can come back for motions. Will they come back and issue a stay, or will they not? If not, does the normal appeal process with oral arguments and briefs take us past August 1 anyway, which would moot the question? The suit would have succeeded to the extent that it could. Meantime, this is notable. The governor of the state, who speaks quite haughtily and as is her custom, she said this is a ridiculous suit and doesn't amount to anything, and they're going to proceed apace with implementation of LEARNS. The Attorney General's spokesman says there's no injunction against it. Well, there's a final order from the circuit court against it, which makes it the law. The governor may be right that plans and implementation can continue and expectation of the inevitable, but I don't believe the Marble School District can currently be under that charter school management system, and I don't believe they can be running the clock on the people trying to do the petitions to refer it to the ballot in November 24. All of this is uncertain. And then if you really want to gum up the works, some gadfly might decide to make something of the fact that what was ruled here, which is that an emergency clause needs to be passed separately from the bill, could make all kinds of trouble for any number of laws passed precisely the same way, with emergency clauses as contained in the same vote as for the bill and recorded separately. I assume sometime during this holiday week, somebody will take action that will begin to clarify some of these things. But flux is what it is. That's what we've got. Good word.
Great minds think alike, I suppose. So
that's all I can think. Yeah.
I knew you were going to say that. So to your point, you make a good point of mentioning that this emergency clause could parlay itself into further action on a number of different fronts. That's one of the things that could happen. I thought there's two other points in the judge's legal ruling too that were of interest. He says that there has not really been any economic harm that has occurred yet to the Marble or Elaine school district. So he seemed to be a little bit more on the state side of this illegal exaction argument that's
right.
And when it comes to sovereign immunity, which was one of the defenses that the Supreme Court Justice Karen Baker used, he said that he seemed to have a contradiction to what the Supreme Court ruling has been on that. So I think that's going to be a real matter of attention.
Certainly in contradiction. I'm sorry, I interrupted. Go ahead.
I'm done. So
okay. Certainly in contradiction to the concurring opinion on lifting the TRO by Associate Justice Karen Baker, a declared candidate for Chief Justice, who simply said, state can't be sued in her own courts, sovereign immunity, that solves this. Judge Wright said, yeah, sovereign immunity is a thing, but it cannot possibly be interpreted to mean that the state can violate its own constitution. It's in the Constitution, but then other things are in the Constitution that are just as meaningful and have to be abided by as much. And to say the section on sovereign immunity says the state can violate other sections of the Constitution, that was his, okay, he said that, and he's the local judge, and his ruling rules, and I happen to agree with him. But Judge Baker is the Supreme Court. What she says goes, and she already signaled that in her concurrence in the temporary restraining order. And you put her with the three, I call them the three most partisan Republican justices who have been voting with the Learns Act and against the plaintiffs all along. I still think we know what the Supreme Court's going to do. But right now, we don't know when they're going to do it and how they're going to do it, and if it will matter how they do it. If we have a normal appeals process with the oral arguments and briefings, this thing could, I mean, then it effectively takes us past the effective date without the emergency clause. And that's just, so who runs the Marvel Elaine School District right now? And how much time do the petitioners have to get this thing referred? Those are things that definitely need somehow to be clarified. Most efficiently, probably, by a stay by the Supreme Court.
As one wise person once said, it seems that things are in flux. So let's move on to the United States Supreme Court.
All right.
We had a flurry of opinions last week. I want to begin with the one that deals with, it depends on how you want to slice and dice it. Did it deal with affirmative action in colleges and universities, or did it deal with race-based decisions for admissions in colleges and universities? What's your interpretation of how that's going to be spun? I think is probably the appropriate word.
Well, I've heard a lot from lawyers, not a lot, but several unsolicited analyses sent by email, and they are saying there is maybe less here than meets the eye, that Harvard can't do what's been called affirmative action in the way they've been doing it, but the Supreme Court specifically said you can still, in the interest of diversity, consider great essays by applicants based on race, or based on, as they could on anything else. And these lawyers are saying admissions offices will have to work harder. It never will be the same as Harvard did it, but special recognition, special consideration on account of race could still be done under this ruling. If you know how the appeals process or how the admissions process goes, you submit an essay, you submit your story, you tell your story, you're in a competitive academic situation in which it could go either way, and these essays can make a difference. And they can be based specifically on disadvantage from race. They could also be made on disadvantage of being a poor white kid homeschooled. You can make that same case. But it's historic. It ends affirmative action, at least as Harvard has known it and as many other institutions have known it. It's unfortunate, I think, because affirmative action is still needed in a culture in which Black people are inordinately disadvantaged. But people are telling me there are ways to deal with it that lessen the effect of this ruling. And we'll just have to see what the smart lawyers say and what the smart college officials come up with. But you can still consider race in a secondary roundabout way, I think.
To pull it back to Arkansas politics, you will see that ruling used in future legislative sessions by conservative legislators who feel like they now have Supreme Court precedent to push for ending affirmative action, not only in colleges and universities, but in other areas too.
In business hiring and set aside government contracts. And that's going to happen in Arkansas. And we've considered, we came up in the last session. and this has that political effect. And thanks for pointing that out. I don't know that it has a great electoral effect. This thing polls all over. Affirmative action polls all over the map. You get different numbers depending on how you phrase the question, which is true of all polling, but there are several ways to phrase the question, just as that there are several ways to spin this ruling in terms of how far reaching it is. But in Arkansas, in the Arkansas legislature as currently constituted, this is going to mean you can't do affirmative action anymore, period. You can't give preferences anymore, period, because the race problem is solved. That's what you're going to hear. And the real racists anymore you're going to hear are the liberals who are saying that blacks are not competent to compete without special consideration. They've tried to completely flip the race issue, and that those trying to make amends and give corrective services to disadvantaged black people are the racists. Everything's kind of turning upside down in our politics. But in terms of what it means, of what how we're going to see it spun in terms of bills introduced in forthcoming legislative sessions in Arkansas, I think you called it precisely. Yeah.
And not just people of color, but women are considered minorities under some definitions in the state of Arkansas. All right, I'm going to stick with my Jeopardy theme here. I'm going to stick with college Supreme Court rulings for 300, Alex. Let's go to student loans, which is another big decision that came down. Basically, the Supreme Court said that President Joe Biden cannot, by fiat, declare student loan debt to vanish. It has to go through the legislative branch. And so they basically shot down his student loan forgiveness program. Some will see it as they shot down student loan forgiveness. Some will see they shot it down as an executive order. What will you say?
I believe, well, I don't know how it's going to be seen. It's going to be seen by different people in different ways. And it's not a strictly partisan divide. But here's what it was. The Supreme Court said, the president can't do what he did. The president cannot. You cannot just unilaterally do that. You can't declare forgiveness of student loan debt in this way, debts to the government in this way, and it exceeds your authority. The White House has already said, well, we disagree, too bad. There's another way we could have gone in the first place. We chose not to go that way, but we're going to go that way now. It's more time-consuming, more arduous. You begin a system of writing new administrative rules under the financial aid laws of the Federal Education Department to direct some of these resources to forgiving debt. And people are saying that's different. You could, and it's going to lead to some legal wrangling over whether that exceeds the authority of the law, but it's a way to do it. It's the regulation writing process in the federal government is arduous. It takes time. That's why they chose not to do it in the first place. But I think they're already saying that's the way they're going to go. Ideally, Roby, but we have not had governmental or political idealism in quite some time. The president would propose it, and if worthy, it would pass as a law. Appropriate the money. That's how you would do that. That's out of the question. If you want to give some student loan relief, student loan forgiveness, you have to find another way. Biden tried the easy way. Supreme Court made what I think is a predictable ruling. Now there are other more arduous paths to take, and that's what's going to happen there. So as with the affirmative action, you can spin it a little bit. It may not be as stark and clear a meaning as it sounds in terms of the headline.
Would you say that it's maybe in flux?
Our theme today, viewers, is flux, F-L-U-X. Look it up and you'll understand everything. Yeah.
All right. John Brummett, columnist with the Arkansas Democrat Gazette. Always good to visit with you. Have a good 4th of July.
You too. Bye-bye.